Good morning everybody, and thank you for coming along to this presentation on the new Associations Law. My name's Libby, I'm from the Associations and Charities branch and I'll be your presenter this morning. So today what we're going to talk about is the effect of the new Associations Law on existing incorporated associations. We're going to go through an overview of the changes, both the changes to existing requirements and some of the new introductions that we'll see when the new laws commence. I'm going to explain the prescribed model rules and how associations can use them when they're updating the rules. And also we're going to talk about some of the transitional arrangements that will be coming in with the new law. Okay, so starting with the new law, on the 1st of July 2016, we're expecting that the new Associations and Corporations Act 2015 will be commencing. It's going to replace the existing 1987 legislation, which applies to more than 18,000 not-for-profit associations and clubs all across Western Australia. So the new laws are going to have a far-reaching impact on our community, which is why we're running these information sessions and really putting a lot of effort into our education program. So starting with the changes and how they're going to affect existing associations. So first of all, there is no requirement for an association that's already incorporated to go through any sort of re-enrolment or re-incorporation process. Anyone that was incorporated on the 30th of June 2016 will still be incorporated on the 1st of July. Their association's name will be the same, their registration number, their Incorporated Associations registration number is the same, and their date of incorporation is exactly the same as well. So if you're dealing with any funding bodies or anything like that and they're asking for something to prove that you're incorporated under the new law, you can provide your existing certificate of incorporation because that is just as valid as it was prior to the commencement of the new law. For committee members, anyone that was the committee under the existing 1987 law will be the committee when the new law commences. So there's no requirement to re-elect your committee or reappoint anybody, they will remain the committee. Obviously if people step down or you go through an election process that will change, but just the switchover between the two laws, it will be the same. And the same with membership. So anybody that was a member of the association under the 1987 Act is a member under the 2015. So there's no requirement for your committees to go through any re-enrolment process with the members either. So that will be staying the same. With respect to applications for incorporation or any change of rules or wind-up applications that may be ongoing, if the process has started prior to the new law commencing, that can continue. So if an association's made changes to its rules in June, they can still be lodged with the Department of Commerce and we will be able to accept them as per. There will be no issues there either. So if you have made changes to your rules recently, please make sure that you do lodge them with the department. Okay, so now we're just going to go through some of the changes to the existing requirements that are being introduced with the new law. So to start off, the rules of an association. All incorporated associations are required to have a set of rules that will include information about the day-to-day running of their associations. They'll also provide information about who the members are, who the committees are, how to call meetings, how to maintain financial records, those sorts of things. So incorporated associations will continue to have a set of rules, but what will be changing is the content of the rules. Under the current legislation, we have what's called the Schedule 1 items. That's 14 matters that each association must include in the rules of the association. And they are straightforward things like I've just mentioned, the membership of the association, the process for calling meetings, custody and inspection of records, those sorts of general governance requirements. What is changing is the Schedule 1 items are being increased from 14 items to 19. And we're introducing some new requirements, like all incorporated associations will need to include a dispute resolution process in their rules. They need to define their financial year in the rules. A lot of associations do that now, but it's going to be compulsory for all groups going forward. There'll also be a requirement for all associations to include something in their rules about the distribution of the surplus property in the event that the association winds up. And surplus property can be distributed to a number of not-for-profit organisations, so an incorporated association, a cooperative, a company limited by guarantee, or to any organisation that has a current charitable collections licence. That will be the distribution criteria under the new law. So you don't need to specify that specifically in your rules, but you will need to include something about what is going to happen to your surplus property. So to help associations understand the changes to the Schedule 1 items, we have a rules checklist which is available on our website, and basically it gives you some information about some of the other general requirements that you might want to think about reviewing in your rules, and it also has a list of all the Schedule 1 items. And any new Schedule 1 items are defined in bold, just to make it a little bit easier for you. So you can find that on our website. Next, nice and easy, the annual general meeting. So all incorporated associations are required to hold an annual general meeting once in every calendar year. It's the time where all the members can get together, provide information about how the association's been running over the last year. A lot of associations use it as the opportunity to re-elect their committee, to elect a committee, present reports, and it's also the time that members receive the financial accounts. So the annual general meeting is still considered the most important meeting of an association, but what is changing is that associations will now have 6 months from the end of the financial year to hold their AGM, and that's an extension from the current 4-month requirement. So if your association's financial year ends on the 30th of June, you now have until the 31st of December to hold your annual general meeting. If for whatever reason you're unable to hold the meeting within that time frame, you'll still need to apply to the Department of Commerce to get an extension. But we're hoping that the additional time will take the pressure off associations, particularly when it comes to preparing their accounts for their meetings. Record keeping. There have been some changes to the record keeping requirements. Associations are still required to maintain an up-to-date register of members, record of office holders and rules of association. What is changing is when a person becomes a member of an association, so this only applies to new members, the association is now obliged to give that member a copy of the rules. That can be a hard copy handed to the member. It could be an electronic copy that is emailed to the member, or if the association keeps the rules on their website somewhere, it will also be acceptable for them to email a link to the rules on the website to the member. It won't be acceptable for an association to say, the rules are on the website, go and find them yourself. You will actually need to give the person a direct link to the information. For existing members, they're not obliged to receive a copy of the rules, so be assured you don't need to go and give it out to all your members, and the requirements that the rules is made available for inspection are the same. So if a member wants to have a look at the rules, they're entitled to request to inspect them at any time. The committee will make them available. With respect to the register of members, we've been responsive to the concerns that have been raised with us about privacy over the years. So what is happening with the register of members is that the association will be able to include an email address in place of a residential or postal address for members on the register. So that means when the member joins the association, they'll be able to nominate to include the residential address, postal address, or an email address on the register, and in the event that a member wants to inspect the record, that is the information that would be made available. And we're hoping that inclusion of an email address on the register will address some of the concerns that have been raised with us over the years. What's also changing is they are bringing in some penalties for misuse of the information obtained from the register of members. So the purpose of the register is really to ensure that the committee members can get in contact with members about association business, so send notices obviously. If there's something happening within the association that they want to write to the members about, keep them informed on things that are happening, that's what the committee uses it for. From the member's perspective, it's about getting in contact with other members for association activities. So it might be that a member is setting up a new initiative and is looking for other interested members to help them with the activities, or maybe they're looking for people to help them with them fundraising activities. So the idea is that that member can access the members register, get the contact details for all the other members and write to them and get that support they need for the association's activities. So with this in mind, it is actually an offence under the new law to misuse that information. And here we're talking about collecting receiving the information from the members register and using it for a purpose that's not related to the activities of the association. And the prime example is distributing advertising materials, be they charitable, religious, political or commercial. That will actually be an offence under the new law. So you need to make sure that if you're accessing the members register, it is for associations purposes. So that's quite a big change there. Okay, so the financial changes. This one caused a lot of stir in Parliament. There were a lot of concerns raised with us during the lead up to the introduction of the new law about the financial issues. How is the financial reporting going to change? How is that going to affect our associations? So starting off with what is staying the same. All incorporated associations are required to maintain true and correct financial records that record and explain all their financial transactions. So you should be able to look at the accounts at any time and be able to see whether it was money going in or money coming out and what was the purpose of the transaction. That is staying the same. The other thing that will be the same is that each annual general meeting, all incorporated associations are obliged to present annual accounts to their members. What is changing is what will be in the annual account itself. So what we're doing is we're introducing a tiered financial reporting system, and it's going to depend on the association's annual revenue as to which tier the association falls into. So basically they're on the screen there. We're looking at any associations in the $0 to $250,000 mark, tier 1 associations. And broadly, their obligations in terms of the reporting will be the same as they are now. There is also no requirement for a tier 1 association to be audited. What I will say there though is if the rules of the association require an audit, if the members request an audit, if it's a requirement for an affiliation or reporting to a parent body, or if it's required for any funding or licensing purposes, even if an association is a tier 1, they should still be getting their accounts audited. So while it's not required under our legislation, if it's required for any other purpose, you will still be required to have your accounts audited. Tier 2 associations are anyone between $250,000 and $1 million, and they will be obliged to have their accounts reviewed each year. It's also a requirement that accounts prepared for Tier 2s and Tier 3s are prepared in accordance with the Australian accounting standards. And we would expect with these sorts of figures that they would probably be prepared this way anyway. In terms of who can review the accounts, first of all, it needs to be someone independent of the association, and it can be anyone who's registered with an organisation such as the Australian Institute of Public Accountants, CPA Australia, a chartered accountant. So anyone that falls into those sorts of categories can review the accounts of the association. And anyone in the Tier 3 category, so that's over $1 million, you are required to have your accounts audited each year. And they need to be audited by someone with a current public practice certificate issued by the CPA or the Institute of Public Accountants. Now, I'm not going to go through, the differences between what's included in the audit report for each tier, because it's going to be very specific to which tier your association's in as to what you need to do. So for that information, we have a section in our transition pack that actually goes through the requirements for each tier and explains what is required for each group. So if you're interested in finding out what your specific reporting requirements will be, have a look in the transition pack. And just to be clear, when these actual reporting requirements will commence. So these requirements will apply to the first financial year of an association that commences on or after the 1st of July 2016. So if your association financial year ends on 30 June, on the 1st of July 2016, you need to start preparing your accounts so that at the end of the 2017 financial year, so 30 June 2017, you'll be able to report in accordance with these tiered reporting requirements. If your association is running on a January to December financial year, then you won't actually need to start preparing your accounts on this basis until the 1st of January 2017. Okay, disclosures of interest. Under the current legislation, all committee members of incorporated associations are obliged to disclose any financial interests, pecuniary interests, that they have in the contracts being considered by the committee. This is being expanded in the new law to include material personal interests. So it's not just going to apply to financial interests. So some examples would be the association is talking about employing a particular business or a particular type of business, and a committee member is employed in that particular field. So that is a direct conflict of interest or a direct material personal interest, because obviously if the association employs the committee member's company, shall we say, then that committee member is going to receive a direct benefit. Another example would be employing a family member of someone who is on the committee. That committee member has an interest in that decision-making process, but it's not necessarily a direct financial interest. So that's where we've sort of shifted away from financial interests only. Another example would be, particularly in certain association fields, we find we'll have one or two committee members that might be involved in more than one association operating in the same sort of industry. So in those situations, maybe more than one association is applying for a contract or some kind of funding. That committee member, if they know that both associations are going to be applying for the same funding, then they have an interest that they would need to disclose in that situation as well. Because obviously they could, I guess, theoretically manipulate the process so that one of their associations receives the contract over the other. So it's better to just remove them from that process altogether. So the requirements will be that the committee member is obliged to disclose their material personal interest in the matter being considered by the committee. That disclosure must be minuted, and then that committee member is obliged to leave the room while that discussion takes place. That is a change as well. Prior to the new law, it's always been a recommendation and a good governance recommendation that the committee member leave the room. It is now actually a legal requirement that they remove themselves completely from the meeting while the decision process is gone through. And the last point is, at the next general meeting of the association, that committee member is again obliged to disclose their interest to the members of the association. And that is even if the committee's gone through the process and they weren't a successful applicant. They're still obliged to disclose that they had an interest in that decision-making process. And really, it's just about, I guess, openness and transparency in the decision-making processes of the association. So it's obviously declared at a committee level, but then it's also made clear to the members that the committee was aware that there was an interest in a particular matter being considered and that it was managed appropriately. So it assures the members that the decision-making process was above board effectively. So we're about halfway through now, and I'm going to move on to, I guess, some of the new introductions with the associations law. So up until now, I've been talking about the changes to the existing requirements. We're actually moving on and talking about some of the new additions, starting with committee and officers' duties. So up front, I'll say these requirements apply to the committee or the board members of the association and any officers that are directly involved in the management of the association. And these officers don't necessarily need to be a member of the association or a member of the committee for these requirements to apply. So here we might be talking about a manager of the association or a CEO, those sorts of individuals as well. These requirements will apply to them. And basically what is happening is we are codifying the existing common law duties on committee members and officers and putting them into the legislation. And the idea here is really to make it clear to committee members and officers what their obligations are under the legislation. So the committee members and officers must exercise their duty with care and diligence, in good faith and for a proper purpose. They must not misuse their position or any information that they may obtain as a result of their position. And they must not allow the association to trade while insolvent. So to give you an idea, particularly around care and diligence, which is I guess a rather unusual term, what does that actually mean for committee members? So basically we're looking at things like being prepared for the meetings of your association. And that might mean reading the papers and making sure you're familiar with the agenda of the meeting before you actually attend. Making sure you're aware of the financial position of the association, reviewing any financial statements you receive. And I guess having a broad understanding of the association's financial position, and if you have any questions, making sure you ask them and get answers, and that you understand what's going on with the association. And that is really important, particularly in situations where you're thinking about entering into some kind of loan agreement or you're applying for grants or funding. How can you be expected to make a decision like that without understanding how it is going to affect the association from a financial perspective? So really making sure that you're aware and understand the association's financials. Keep yourself informed about the association's operations and activities, particularly if the association is starting up some new activities. As the committee, you are responsible for ensuring that the association has any public liability insurance or the proper fundraising permits. Maybe you need an occasional liquor licence. It's your job to understand what the association will need in order to see these activities through. So it's very important that you actually are aware of what's going on within your association. You need to take steps to make sure your association complies with its other legal obligations. So here we're talking about things like if you're employing staff, understanding your obligations as an employer. You need to provide a safe work environment. You need to make sure that your association's appropriately registered, from a taxation perspective. You need to be aware that you're paying your members superannuation entitlements, for example. If you're involved in particular activities, you need to make sure that you have the appropriate insurances. So these are all the sorts of things that committee members need to be aware of when they're making decisions, and these are the sorts of duties we're talking about in terms of care and diligence. And if you're freaking out at this point, I will say that our Inc. guide, our Good Governance Guide for Incorporated Associations, available on our website, includes a lot of information about these things. So if you're looking for a starting point on what your taxation obligations might be, I'd say go and have a look at the taxation chapter on the Inc. guide. Gives you some basic information, and it tells you where you can go to find the relevant organisations that you'll need to speak with. The other point I will make with duties is that there are defences under the new law. So basically, if a committee member has made a reasonable decision based on the information available to them at the time, and for whatever reason the outcome is not favourable, so they've decided they're going to run this event, they go through, they organise everything, and unfortunately that event still runs at a loss, that does not mean that the committee member has breached their duty. It simply means that it didn't pan out that time. So yeah, just be aware of that. As long as the person has acted, I guess, in good faith on appropriate advice and information, we wouldn't be of the view that they've breached their duty. If, however, everybody has said, no, this is not an appropriate thing to do, your accountant, your lawyer, the rest of the committee, anyone else that you've spoken to have said, no, this isn't going to work, you shouldn't be looking at pursuing this, this option, and the committee member pursues it anyway, then there may be a case to say that they're breaching their duties. Okay, dispute resolution. So as I've mentioned before, the Schedule 1 items are being increased to include the requirement that all associations have a dispute resolution process in their rules. So that is the first step in resolving any disputes you have between your members or any disputes that are occurring within the association, is follow the dispute resolution process that is put down in your rules. And I would be encouraging groups, if you find you don't have a dispute resolution process, we'll get your rules up to date as quickly as possible. And the sorts of things we're looking for in a dispute resolution process is really just, I guess, the principles of natural justice, where if a concern is raised about a member, they are made aware of the issues that have been raised against them. They're given an opportunity to respond to those issues or those concerns. And in the event that, I guess, the decision is made against them, they're given some opportunity to appeal that decision. So that's really what we're looking for in a dispute resolution process. If, however, the members go through that process in the rules and are still unable to reach a satisfactory outcome, under the new law there will be the option for either party to refer the matter to SAT. So that is a state administrative tribunal. So you will now be able to make an application to the SAT, who will be able to refer the dispute to mediation or give orders directing that the rules be followed, or enforcing the rights of a particular member. Let's say the the rules include a clause that said all documents and securities are open to a member to inspect. So that's what the rules require, and the association is refusing to make that document available. Maybe a member wants to see a set of the minutes. The SAT will be able to give an order that that particular document is made available for inspection in accordance with those rules. So that's really the sorts of situations where the SAT may become involved. But I would say as a first step, go through the dispute resolution process in your rules. If you have any peak bodies or parent organisations that you can seek assistance from, particularly sporting clubs usually have a pretty good hierarchy that they can go through. Make sure you utilise the channels available to you, so hopefully we don't get to the stage where things have to go to the SAT. Okay, some of the other new provisions. So the powers of the Commissioner for Consumer Protection, who's responsible for the administration of the Associations and Corporations Act, have been increased somewhat, but what I will say is that the powers that are being introduced will be options of last resort. So we're not expecting that we're going to need to utilise these powers often. One of these powers will be that the Commissioner will be able to direct that an association hold a general meeting. And the thought behind this is if there is a dispute occurring in the association that has got to such a stage that it is affecting the way the association is operating, then calling a general meeting to discuss the matter may be a way to work through the issue. So the Commissioner will have the power to step in and direct that the meeting is called so that that particular issue can be discussed. To be clear, the Commissioner doesn't get a vote in the decisions that are made by the association, and the department is not involved in, I guess, the meeting itself. We're really just saying you need to call a meeting, and then the members will deal with the dispute themselves. So that's one of the new powers. The other one is that the Commissioner will be able to apply to the State Administrative Tribunal for the appointment of a statutory manager. And a statutory manager will basically step in and take on the roles and responsibilities of the committee, either for a specific period of time or until the SAT is satisfied that the issue within the association has been resolved, and at that time the running of the association would be returned to the committee. Now, it is a big decision to say we're going to remove the committee from their position within the association. Obviously, you'd expect the committee knows the purposes of the association, knows its membership far better than an outsider would. So it will be an absolute option of last resort. So hopefully it's not a power that we will need to use often, but it is one that will be included under the new law. Amalgamations. Under the current legislation, there is no, I guess, formal process for amalgamating more than one association, which can make things a little bit difficult. Particularly we see it a lot in sporting clubs where there might be a junior and a senior club who are incorporated separately and decide it would make more sense to merge their affairs and merge the activities of the association. There is no easy process at the moment to allow these two groups to merge. So we have introduced an amalgamation process. Basically, it will require each association who's going to be party to the amalgamation to pass a special resolution confirming that they want to amalgamate and accepting the rules and the name of the new merged association. So each association that's going to be party to this merger goes through that process, passes a special resolution, and then all they'll need to do is submit all the relevant documents to the department, and we will be able to go through and dissolve the existing associations and set up a new one. So, and all the association's properties will be able to be rolled into that new association without any particular issues. So we're hoping that that will streamline things for associations that are looking to amalgamate with other groups. And the other new provision that we'll be commencing is, I guess there will be notification requirements for associations. At the moment, there is no requirement for associations to notify the department if they change their address. So we have 18,000 associations, and if we're lucky, we think we might have about 12,000 addresses that are current. So as you can see, it puts us at a little bit of a disadvantage when it comes to getting the information about the new law out to our associations. So in the new world, where an association changes its rules, it will be obliged to lodge notification of the change of address with the department within 28 days. And you will be able to do that online using our association's online system without any real fuss. So that is one change that is coming. So when you elect a new secretary each year, if the address that's recorded with us is their personal address, make sure that you update that information with us. If an association has a PO box or a registered address that, like an office that they use pretty much all the time, then there's probably not going to be such an issue. They'll need to update that information with us once, and then going forward it probably won't need to be done too often. The other change is that we will be introducing some annual information statements. To be clear, they will not be onerous requirements for incorporated associations. We will not be requiring copies of minutes. We will not be requiring any formal reports to be written to us, and we won't be requiring copies of financials to be lodged with us each year. What we will be doing is setting up an online information statement form, and we'll be asking for information like, does your association still have 6 members? When was your last AGM held? What is your current address? If you haven't lodged it with us, you'll have an opportunity to do it then. And confirming that your association is meeting its financial obligations. So you might be obliged to tick which tier your association is, and then confirm that yes, you are presenting your accounts in accordance with the requirements of that tier. So that's really what we're looking for in terms of annual information statements. Now, just to be clear, what I've given you is examples. Until the regulations have been confirmed, we won't be able to tell you exactly what is going to be in the information statements, but I guess that is what we're proposing to include, but it's still subject to final approval. And we're not anticipating that the annual information statements will start on the 1st of July. We'll probably be delaying that potentially to the end of the transition period. So please keep an eye on our newsletters, our social media and our website for information about when the annual information statements will be commencing, because at the moment we can't tell you for sure. So moving on to the prescribed model rules. At the moment, the department has a set of model rules available to assist associations when they're becoming incorporated or going through a process of updating their rules. And basically it's a pro forma constitution where you just fill in the blanks and you can adopt that as the rules of your association. Under the new law, the prescribed model rules are actually going to be put into the regulations. So at the moment, it's really just a good governance document that's recommended by the department. This one's actually going to be enshrined in the law. So what the associations will have the choice of either adopting the model rules in their entirety, in which case they provide us 4 pieces of information: the name of the association, the objects of the association, the quorum for a general meeting and a committee meeting, and they confirm their financial year. That is all the information that associations will need to provide to the department if they choose to adopt the model rules. So that is one option available to you. Everything else is provided for in the model rules document. To be clear though, if you change anything in the prescribed model rules, with the exception of those items that I just mentioned, you won't be considered to have adopted the model rules anymore. It is still open to associations to have their own rules that are completely different to the prescribed model rules. There's no issue with that. So if you have your association set up in a particular way and you're very happy with the structure of your rules, then there will be no problem with you continuing to use that document going forward. And also, you may still want to refer to the model rules for information about setting up, maybe you considering the dispute resolution process that is in the prescribed model rules. You can always look at that, decide that that is what you're going to adopt in your existing document. But just to be clear, if you do use the model rules, you won't be able to change anything within the document. It will be you accept it as it is. And the model rules are available from the department's website, and they will be included in the regulations that are approved probably around July this year when the new law commences. So just be aware, while we're not proposing to make any changes to the document, it's still considered to be a draft for the time being until it's approved as part of the regulations process. Once the new law commences on the 1st of July, there are some things that incorporated associations will be required to do in order to transition over to the new law. The first is to provide us with a current address for service. So within 3 months of the new law commencing, all incorporated associations will be obliged to notify us of their current address. So as I said, at the moment we've got 18,000 with 12,000 addresses. Hopefully at the end of 3 months we will have 18,000 addresses. We can be very hopeful on that. If your association is currently enrolled with our Associations Online system and you are confident that the address that you have registered with us is the correct and current address for the association, we are writing into our regulations that we will be able to accept that as the address for the purposes of this transitional requirement. So if you are already enrolled in Associations Online and your address is correct, there will be no requirement to re-notify us of your address details. All incorporated associations will need to go through a process of reviewing their rules and updating them to ensure that they comply with the requirements of the new law. So here is where we're talking about if you are missing some of the Schedule 1 items that will be required by the new law, you'll need to update your rules to include those matters. Maybe you need to add in a dispute resolution process, or maybe you're not defining your financial year at the moment. That may be the only update that's required. To make it easier for associations though, we are providing a 3-year transition period in which these changes to the rules may be done. So don't panic and think 1st of July you need to have your updated rules lodged with us. You have 3 years, and that should be plenty of time for you to go through the process of reviewing your rules, making sure they are still relevant to the needs of your association, and then taking the necessary steps to see that they comply with the requirements of the new law. And I guess the other point that I'll make here is during this 3-year transition process, to ease the burden on associations, committee members will be able to pass the changes required to update the rules and lodge them with the department without going through the process of calling a general meeting of the members and passing a special resolution. To be clear, that is a one-time only offer. Once the committee has passed the changes required to get their rules in line with the new law, the usual requirements of making changes with the membership involved will kick back in. And also to be clear, you can only change the rules to meet the requirements of the new law. You won't be able to change the name or the objects without going through the special resolution process with your members. So just be very clear on that. If all you need to do is insert your dispute resolution clause or your financial year, the committee will be able to do that on behalf of the association. Alternatively, the members, the committee can still decide that the members should be making the changes and call a general meeting and go through that usual process if that's what you'd prefer to do. Looking at your options, you can choose to adopt the model rules, or you can look to update and rewrite the requirements in your existing association rules. It will be completely up to each group which option is best for them. The changes to the rules will still need to be lodged with Consumer Protection in order for them to take effect. So you'll have 28 days from, let's say, when the committee passes the change to lodge them with the department, and you'll be able to do that online using Associations Online. Once the document has been accepted by the department, you will need to notify your members that the changes have been passed. So this applies in the situation where the committee has made a change on behalf of the association. So at the next annual general meeting, with the notice that you send out to your members, you'll need to include a notification that the rule change has been completed. Once you've done that, as I said, you've made the transition to the new law, and you'll be able to just get on with the activities of the association as per normal. Okay, so finishing up, where do you actually find information about the new associations law, the transition processes, enrolling for associations online, what have you? The department has a range of resources available for associations, and we will be continuing to add to this collection and update the information. Everything we do is available online, so if you go to the department's website, you'll be able to download copies of things like our transition packs, you can get copies of our checklists, you'll be able to access the Inc guide, everything is available online. So the Transition Pack is one tool that we have available to help associations navigate the changes to the new law. Transition Pack 1 was released in February and provides an overview of the changes, goes through the financial reporting requirements for each tier, and also provides committees with some information about basically the day the new law commences or when the law commences, what will they need to do first. And that's really the things I've been talking about here in terms of updating the address details with the department, looking to review your rules, maybe making the members aware that the changes has happened and that the new law has commenced, and probably assuring them that it's not going to affect their statuses as members of the association. So we will be releasing more transition packs along the way. Please sign up to our newsletter, keep an eye on our Facebook and our Twitter accounts, have a look on our website, because when we release information, that is how we will be making our associations aware of it. We also run information sessions on occasion, generally around the Perth metropolitan area. That's why we have a copy of this presentation, the slides, on our website. If you want to have a look at them in more detail, that is available as well. Okay, and the new law references. If you're looking for a copy of the new law, that is available from the State Law Publishers website. You can download it for free. If you'd want a hard copy, I believe you do actually have to purchase it from them. So I would definitely be encouraging everybody to have a look at the online free version. The model rules are available from our website. As I said, at the moment they are still technically a draft, but we're not expecting that there will be any changes to the document. So, you know, please definitely have a look at them and start thinking about whether your association would prefer to adopt the model rules or whether you'd prefer to rewrite your existing rules. And the last document, I guess, relevant to the new law is the regulations. As I said, that is not currently available, and it is not likely the regulations will be available to the public prior to the commencement of the new law. But for the most part, the regulations include information about what will be required when lodging forms with the department, information about, you know, fees and infringement notices and those sorts of things. So I guess the documents that we have available now, the model rules, the Act, the transition packs, should be more than enough to help get your association through that transition process. I suppose that until the new law was proclaimed, all we can say is that it is expected to start on the 1st of July. It hasn't been officially approved to start on that date, but by all accounts, everyone is working towards 1st of July weeks, but we would be 99.9% sure that 1st of July will be commencing. Generally, yes. We are considering options to either reduce the fee or waive it for the purpose of the transition period, but any other time, if an association needs to update its rules, you're looking at $24, yes. Probably not. Any association that adopts the model rules only needs to give us 4 pieces of information, and the rest is obviously provided for already in the document. And any future changes to the model rules, if we decide to update anything at any point, will automatically be updated for those associations. So if an association that hasn't adopted the model rules wants to make changes, they'll need to go through the process themselves, as opposed to it sort of being done automatically. While we do have offence-making provisions in the Act, we are aware that we're dealing with volunteers, and also the nature of committees means that a lot of knowledge goes through the association when people leave. So I guess as the first point, we would be looking at providing educational advice to the association and helping them get it back on track and making sure that they do comply with those requirements in the future. As far as I'm aware, the changes to this law aren't going to have any impact on that system. The law is changing in that associations will be able to trade under the new law, provided that any income that they generate is put back into the activities of the associations. So there are some restrictions on trading that are being lifted, but I can't comment whether or not it would change your situation. Yes. I think where possible we are lining ourselves up with the ACNC, which is the Australian Not-for-Profits and Charities Commission, with a view to making it easier for associations. So our tiers are matched up with the ACNC, our reviewers and auditor requirements matched up with the ACNC, and where possible we'd be looking at making our information statements similar as well. I am from the Associations and Charities branch of the Department of Commerce. If you're looking for more information about the new laws, I would say go to our website first. As a second point, we do have a dedicated Associations General Inquiry team who you can call on our 1300 number, and they'll be able to provide answers to any questions you may have about how to enrol for associations online, what changes are required with the new law. They'll be able to help you. We also have an association's email address, and we'll be able to take inquiries there as well. Thank you very much for your attendance this morning. If you have anything else that you think of after, please feel free to come and have a chat to me. Other than that, thank you very much for your attendance.